Hi, Phil Hundl here. We're continuing on with our series of the condemnation steps and the things that you can think about or know a little bit more about in each step, and things that you can do as a landowner to help improve the process for you. So we're at step 1B, and this is you've just been initially contacted by a right-of-way agent, and whatever the project is, if it's a power line, pipeline, or road expansion, it's going to vary slightly what they're wanting or needing to do. But one of the things that right-of-way agent is going to be asking is whether they can have temporary access to do initial surveying on your property and other inspections or other surveys, they'll call it. And so what does that mean? Okay, so for pipelines, just for example, they'll oftentimes will need to enter the property to conduct further civil engineering or civil surveying to finalize a potential plat of the route of the pipeline. If there's water bodies or there's bodies of water on the property, rivers, creeks, lakes, they may also need to do some archaeological studies, and then there's also some environmental studies, endangered species studies that they often need to do, and they will ask for that type of access. So, what if you rather not have them access your property to do these initial surveys? You can absolutely say that you're not interested, and once again, some of your initial responses to the right-of-way agent is and should be, provide me more information about this project and exactly what you propose or intend to do on my property. And then you can absolutely express your, desire to not have this project on your property, and they can go somewhere else. Absolutely, you can do that, as well as if there are some, preferred routes for the power line, the pipeline, absolutely, voice your opinion on that, express that to the right-of-way agents. I always suggest, in writing if possible, on their simple diagram that they've sent you or aerial about the route, if you've got a different preferred route that you would like this project to go on, then go ahead and let them know, as soon as possible. Um, you know, Once again, this is your initial thought of where do I want this pipeline if it has to be on my property. I think the first answer most of the time people have is I don't want it at all, so therefore not interested, go away, and that's absolutely fine. However, if it's going to have to be on my property no matter what, and that's what you're telling me, then start looking at these other potential routes. I recommend that. This is where if you get a lawyer involved from the beginning, the lawyer can help you with expressing your desires and interests related to preferred routes or preferred, routes for a power line. Um, Getting to better know exactly what they're also wanting to do on your property is extremely important. We've mentioned that, but let me go a little bit further. Sometimes people will say, "Well, it's a pipeline, I understand, and it's going to be underneath the ground." Well, it may or may not be completely that on underground on your property. They may need a valve site. They may want an access road. They may want a larger surface site. You just never know, and so getting that additional information from the right-of-way agent. And oftentimes the right-of-way agents won't have that information or won't know because they're only given limited information as well. But that's information that we need as soon as possible so that we can start evaluating how bad this is going to affect your property. Getting back to temporary access. At some point, if you're not willing to allow the condemnor, and I'm just going to refer to them as the condemnor in the situation, be it a pipeline company, the government, if you're not going to allow them on your property, then they will oftentimes file an application for a temporary restraining order, essentially asking the judge, give us an order allowing us to go on the property, even though the landowner isn't giving us consent. and that oftentimes happens. It's happened recently in some pipeline projects where the pipeline company, frankly, doesn't want to wait around to get consent from the landowner. They're just going forward with asking the court to give them access. And the issue with that is the access that the court is going to give the pipeline company or power line company is probably going to be very broad. And so, in an effort to limit the access to just what they need for the amount of time that they need, where they need to go on your property, and just have a lot more limitations on their access, many times, most of the time, we end up, we being, the landowners in these condemnation cases, enter into limited temporary access agreements. And that way, you know, kind of both sides are getting what they need. The landowners getting these limitations on the condemnor, and the condemnor is being able to access the property under these constraints, be it limited the time frame. Well, number one, the date, the date or the length of time. Maybe it's only a week, 2 weeks for access. Maybe it's a month for access. But limited the hours, the days of the week, not on the weekend. Sometimes I've had clients that want it on the weekend. Okay, fine. So whatever works best for the landowner. If the landowner wants to be there present at the same time, those are also things that we ask for. Also, maybe the landowner is going to let the survey crews in and be there, or the landowner is going to let the crews in the first time, and then the condemnor is going to put their own combination lock, interlocked with the other locks, and that way they can come and go without the landowner having to be there. It just depends on what you, the landowner, need and want, and those are the things that we try to get in the limited temporary access agreement, as opposed to a court granting a very broad temporary restraining order that then turns into potentially a temporary injunction. So hopefully that's helpful. Step 1B is what we call this section, and then we'll move on to the next step.